Testifying against House Bill 4218.
Yes, good afternoon, Mr. Chairman, members of the committee. Laura Tamez, Texas Trial Lawyers Association, and testifying on their behalf against the bill. At the end of a very challenging session for all stakeholders involved in HB 19 commercial motor vehicles, due to the good work of this body, as well as you, Mr. Chairman, we were able to come up with a balanced bill for all Texans and companies alike. It's an honor to meet with stakeholders, and at your direction, we did make the attempt over the last couple of weeks to do so. We finally met last night, had a conversation, and came away with the perspective, or a new perspective, because the question became, why would a rental leasing truck company who rents out for personal use want to live in the code that is now Chapter 72? When if Chapter 72 contemplates employer, employee, principal, agent, that where the employer is going to stipulate to course and scope, and that is their employee to derive a benefit of a bifurcated trial, then what would, because there's a Graves Amendment that really exonerates them from vicarious liability, why would they want to be, or what would be the benefit derived in the bill? After, having a conversation and understanding their thought process, and looking at or going back to the history of last session, personal use was specifically excluded. First of all, it is now brought back into this bill. The condition of the vehicle was a real concern in terms of putting vehicles on the road that were dangerous, that weren't properly maintained with equipment. Within the new 053 subsection D, there are, yes, terms like retrofit and component parts and equipment that are not defined, that could be, if as broadly as they are currently, could be they didn't install proper brakes. Negligent maintenance was something that was kept out of the bill. If there was negligent maintenance, that would live in the first phase, and all of the evidence would go into the first phase. But here, in again, subsection D, line 19, evidence related to that is not admissible in any phase of the trial. Evidence related to maybe a new standard of care when it comes to whatever equipment or retrofit is concerned. So without those definitions, it leaves, it's a broad stroke. It would really cover all commercial motor vehicles, not just the leasing company, and those are the concerns that we had. But with that said, before this hearing, we have committed to, since everybody's here, not everybody, but some of the stakeholders are here in town, committed to, after this hearing, visiting with them further, now that we've got a news perspective.
Okay, that's great to hear. Thank you. Yes, Chairman Moody. Thank you, Laura.
Thank you, Laura, and I apologize I missed a portion of that. It's just that time of session. I had tried my best to just kind of forget everything from last session, but you've now brought some of it back to my attention. And I had a great meeting with the folks from Penske, and so understand, and I know the spirit of HB 19. Those were very, very detailed, very, we got into, minute details of federal regulations. Really got into the weeds on all that, up and until the point it came to the House floor, which is a testament to the willingness of everybody to work on it to get it right and to get people to come together on it. But it also means that I think this body, and I'll include myself in that, is going to want to be very sensitive to and very laser focused. If there's something that maybe was missed or needs to be tweaked, I just want to, that's the direction I want to give folks to do, to do a little bit of service to the work that we put into.
Chairman, I made that clear. Did you miss my
I had a meeting outside. I apologize.
I said it very clearly in my layout. We're not going back on HB 19.
No, I'm just kidding.
No, we do believe that this.
No, I know. And those negotiations, and everything was, everybody was working hard, very hard at the table, all parties involved. And so I know, and I just want to reiterate that from my perspective, if there's something that needs to be tweaked, I'm not opposed to it, because we know what the spirit of what we were trying to get at in those negotiations was. And so if we can keep in line with the spirit of that without disturbing what we settled, then let's figure that out. And I'm glad that you all are committed to working with all the parties. That's the best way to work these things out. So thank you so much. I appreciate your comment.
Thank you, Chairman Moody.
Yeah, thank you. Well said. Members, any other questions for Laura? Thank you. The chair calls Steve Bresnen.
Thank you, Mr. Chairman. My name's Steve Bresnen.
Hang on, Steve. I'm going
Yes, sir.
to introduce you for you. You're here testifying on behalf of the Texas Trial Lawyers Association against House Bill 4218, correct?
Yes, sir.
All right, go ahead.
Okay, thank you, Mr. Chairman. I want to follow up on my president's explanation about how this opens up HB 19 in at least two ways. It strikes the current definition of personal use and replaces it with one that if you make personal use of your Suburban, it's a rented Suburban, and it's over 6,000 pounds, which they run about 6,100 pounds, is according to the internet, if you can believe that. Then under this bill, it would be a commercial vehicle because you rented it. And I'm specifically looking at on page 2, lines 1 through 7. It's if you're using it for personal, family, or household purposes, it's not a commercial motor vehicle unless it weighs at least 6,000 pounds, and the owner's liability is governed by, that's the Graves Amendment that's referred to on line 8 there. So it would become a commercial motor vehicle even though you're using it for personal, household, or family use. That's a significant deviation from House Bill 19. The second place it does is on page 2, lines 11 through about 2/3 of line 13. In a civil action under this subchapter, the duty of care applicable to an owner, lessor, or operator of a commercial motor vehicle involved in an accident, I'm going to skip the next phrase, does not include an obligation to retrofit. In the middle of that, or a person renting the vehicle to another person. So the first phrase takes in every commercial motor vehicle. That was not part of House Bill 19. And it goes beyond the renting of a motor vehicle as I read it. Not only that, as Ms. Tamez pointed out, that was about vicarious liability, employer-employee relationships, House Bill 19. This provision, whatever its merits, doesn't have a thing to do with employer-employee relationships. It is simply in the wrong place. Even if you like it, it has no business being in subchapter B of Chapter 72. A couple of quick more points.
It's not in subchapter B, though. It's in subchapter D.
No, sir. That's a subsection D of that's within subchapter B. Yes, sir.
B. Okay, got it.
I've passed out to you the current products liability law, which the most recent major amendments were in 2003. The Texas Supreme Court, the Fifth Circuit Court of Appeals, and the First Court of Appeals have held that the provision of 82.008 there, which is on page 2 in the middle of the page, provides a government standards defense where there's a product involved, a truck is a product, and there's a seller involved, and the definition of seller on page 1 clearly includes people who rent trucks. Here's 2 sentences of what the Texas Supreme Court said. The Ruizes have not, for example, alleged that the Spectra is defective because it lacks an additional occupant restraint equipment, such as a third frontal airbag that federal standards do not require. Had that been the case, the presumption in 82.008 would have applied. They applied the right case, and I can give you the citations to all of these, and Hamid applied the right case as well, which was the Fifth Circuit case. The status of the law right now is that this section 82.008 governs this issue. This is not required legislation. The company pled it. The company supported it with citation. They did not prevail on summary judgment. In the one case in this state that's gone anywhere, and it was settled in Dallas. After that summary judgment, they did not prevail on. There are no other open cases, despite a provision, the last provision in the bill, that would apply this bill to pending cases. So the law is already well stated. There's no crisis here. There was one case, and it opens up House Bill 19, which we respectfully request you not to do.
We're not going to do that.
Thank you, sir.
Steve, thank you for the members. Any questions? All right, our last.